Good evening, everyone. Glad to be here, and I invite everyone to welcome you to the June meeting of the Washington County Quorum Court. I've called the meeting to order. With that, we're going to move on into our agenda this evening. First up is prayer and pledge, and I believe that Justice Willie Lemming has agreed to do us that honor. Justice Lemming?
Thank you, Judge. Let's pray. Father in heaven, we love you. Thank you for everything you do for each and every one of us. Father, forgive us for where we fail you. Be with us tonight as we conduct the business of the county, and everybody have open hearts about everything. We ask all this thing in your Son, Jesus Christ's name. Amen. Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Justice Lemming. With that, we'll move to the adoption of the agenda. Do I have a motion to adopt the agenda? Justice Bruns?
Before we move, I would like to ask, have we yet got anybody that can enforce the ordinances that we're looking at trying to pass tonight?
I don't understand your question, sir. The Sheriff's Department enforces our ordinances.
Sheriff's Department doesn't.
Okay. Yeah, they're supposed to. Do we have any motions with regard to the agenda? I have a motion to adopt the agenda by Justice Ecke, a second by Justice Dean. Do you have additions or modifications to the agenda? Justice Rios Stafford?
Thank you, Judge. I would like to move to put items 12, 13, and 16 on a consent agenda. I think when we were in committee, we forgot to create a consent agenda this month.
I have a motion by Justice Rios Stafford to put items 13, 14, 15, and...
I'm sorry, 12, 13, and 16.
Oh, okay, I'm sorry. 12, 13, and 16 on a consent agenda. And I had second by Justice Ecke. Did I believe you said... Oh, I'm sorry, Justice Lyons seconded that motion. All those in favor?
Aye.
Those opposed? I do not think those will go on a consent agenda. If there's justices, okay. Back to the original motion. I had a motion to adopt the agenda by Justice Ecke, second by Justice Dean. All those in favor? Aye. The agenda has been adopted. Next up are preliminary motions. Do we have any preliminary motions this evening? Justice Dean?
Thank you, Judge. Yes, I'd like to make a motion that all ordinances and resolutions be read by title only.
I have a motion by Justice Dean to read all ordinances and resolutions by title only. Do I have a second? Second by Justice Lyons. All those in favor? Aye. Those opposed? Resolutions and ordinances will be read by title only. Next up are citizen comments. We have a 15-minute comment period with a limit of 3 minutes per individual. Citizen comments. Please come forward and state your name and where you're from. You're going to hit that button on the bottom right. There you go.
Thank you. I'm Nikki Lockett. I live off Greasy Valley in Prairie Grove, and I am asking the court to consider putting on a future agenda, a very soon future agenda, and vote on passing a 5-year moratorium against industrial wind farms, which they really are power plants. They're industrial. An example is in Carroll County. Some of the sizes are 656 feet tall, which is 60 stories high. The tallest building in Arkansas is Simmons Tower in Little Rock, which is 40 stories tall. So one of those turbines is 1.5 high of the highest building in Arkansas. Each one of those that size would weigh 1,433 tons, which is 2.7 million pounds. Just to put it in perspective, the snowplow that ran over Jeremy Renner is 1,433 pounds. One of those turbines would be 2,000 of those snowplows. And now that we appear to be in Tornado Alley, especially the Lincoln area, as most recent weather events, it's a little concerning. But there's some other things. I've been immersing myself to learn about this the past few weeks and listening to personal story after personal story, which there's plenty to find on the internet all across the not just United States, but the world. And the common theme is we have been lied to. There's issues with shadow flicker, with red light flicker, infrasound, which is low frequency, which can lead to mental health, psychological distress, disrupt sleep, heart health, anxiety, fear, migraine seizures, tinnitus, vertigo, ground vibration. And the thing is, there's no off switch. Once these go up, That's it. And also, there is a company in 2022 that pled, a wind energy company that pled guilty to killing at least 150 eagles, likely more, because they couldn't find all the carcasses. On the USGS.gov website, quote, "Dead bats are found beneath wind turbines all over the world. It's estimated that tens to hundreds of thousands die at wind turbines each year in North America alone." I've seen videos where they're blowing up parts of ridges to put, trees are decimated, roads that are not in existence. They go ahead and build, they modify and widen existing roads. Who pays for this? The taxpayer. And the damage to the roads. And then people's lives, they live in rural areas for a reason, for peace, and these are industrial wind power plants. They're not farms. Trees and landscape are decimating. Clearing the trees will create more runoff. Moores Creek runs into Lincoln Lake, and Moores Creek is part of the Illinois River watershed. And what impact would having this over on the ridge off Jackson Highway by Lincoln Lake have to that? The other thing, it's one thing to measure sound, which the wind companies will tell you, we measure it. It's a different thing to measure the effects of that sound on a human being. I would ask you not just to listen to the expert, but listen to lived experiences of people. And a quote from one person I heard say, "Few get rich off the detriment of many." And about private property rights, utility companies can enforce eminent domain, which takes away those property rights. Thank you.
Thank you. Public comments.
Hello, my name is Michael Kemper, and I live at 14307 Jasper Lacey Road, and we share a north-south property boundary with Ms. Mrachik. At the June 5th, 2025 planning meeting, it was discussed at length about all the little changes in language that had been made to the planning committee guidelines, and it was also explained in detail how all these little nuances were necessary for the preservation and protection of the quality of rural life in Washington County. And shortly thereafter, they moved that this CUP for Alley would go forward. I have some safety issues I'd like to share with you about that project. First, there's the sight distance safety issue, and the application asks how far can you see in each direction from the driveway as you're leaving. Alley answered, well, it's good visibility, but quite frankly, that simply isn't true. I pulled out of that driveway the other day in my big old Silverado pickup, and at best I could see 100 feet in either direction. And in that particular part of the road, people travel 45, 50, and up from there miles an hour, taking a run at that mountain. Well, anyway, secondly, I'd like to speak to you about the fire pits that she's wanting to have. That opens up a whole nother list of safety concerns, especially during those long dry spells we often have. Having spent the majority of my life, my adult life anyway, in leadership positions with youth group clubs that like to go start fires. You know who this group is. Anyway, I can tell you from my experience, those fire pits are a forest fire waiting to happen. That's just not good. Okay, Round Mountain Fire Station is right across the street from there, but that's an unmanned station, and the likelihood of there being an immediate response just out of the question. It's not going to happen. Now, speaking of the fire department, at the last meeting, just before the vote, it was mentioned that the fire chief didn't see why the business couldn't operate safely. I have the utmost respect for Shane Wood, I really do, but he does not live in that area and would not be impacted by this. His dad, on the other hand, is former Round Mountain Fire Chief Ronnie Wood, lifelong resident of the area, personally told me that he didn't want and doesn't think our community wants or needs the business. Over the past few weeks, my wife and I have personally spoken to many of the community members, including the neighbor notification map list on, and to some folks that were not. Not one single neighbor expressed that they think these events or this project would have a positive impact on our residential community or property values or our quality of life.
Thank you, sir. Time's expired. Public comments.
Should I push this? Hello, my name is Betsy Kemper. I live at 14307 Jasper Lacey Road, his wife. I recently had a conversation with Richard Murphy. He's a supervisor for environmental management for the Arkansas, Northwest Arkansas region. He told me that,
Ma'am, you're gonna have to pull that microphone closer to your mouth. We have
I'm
certain individuals up here who can't hear. What-
Okay.
Thank you.
okay. I recently had a conversation with Richard Murphy. He's a supervisor for environmental management for Northwest Arkansas region. He told me that the county has not responded to the state's request regarding that the septic system is adequate for what Ally is proposing. And that is a 2-building B&B that has a total of 3 bedrooms and a 10-person sauna with 3 back-to-back sessions of 2 hours each. The cold water dousing outside is not my concern, but what she states in her proposal. She states in her proposal, guests can change and shower in one of the 3 existing full-size bathrooms. The other place is guests can shower off and use the facilities of one of the 3 existing full bathrooms. This means it's possible that 30 showers in a 6-hour period in the 2 B&Bs in one day, not to mention the other bathroom duties. Ally confronted us when she left the planning meeting last time. She said no matter what, she will be putting in a 10-person sauna and use it for the 2 buildings. I said, well, at least there won't be 30 cars coming and going and 30 showers taken back to back. She responded, well, there just might be. To me, that implies she's planning on having quite a crowd in the 2 B&Bs. If the septic reliable for that, this is pretty old property, and the original house had only 1 bedroom. I can't imagine the septic that was put in then would be compatible to what she intends to do now. As of now, the state has not approved the plan and the existing system. I would also like to add a side note. At the planning committee, Ally was given a chance to speak last. She said that she had talked to all the neighbors with no objection. That's a flat-out lie. She did not talk to the neighbors, but Michael and I did. 15 neighbors that said they knew other people that didn't want and would tell them about this CUP coming to our neighborhood. Not a single person wants this to happen. That said, I know from court member here that doesn't hold water. You have a clause in your letter of explanation about compatibility. I was also told by a member that that was put in just to get it to pass. That doesn't mean a thing. I would suggest one of you should...
Ma'am, I'm sorry, your time's expired. Your 3 minutes is up.
I didn't hear the buzzer.
Well, Public comments?
Thank you again for all of the hard work that you do. I'm Charles McKinney, 19956 Lakeview Road. I want to be clear, if the county allows Eagle Crest to operate without a conditional use permit, it will set a precedent. Any other similar facility will expect the same treatment. Now let's be concerned. If the next Eagle Crest moved into the house next door to you without a cup, without addressing fire safety or septic regulations, and no requirement to address neighborhood concerns, how would you feel? Eagle Crest is not a single-family home. It's a commercial treatment facility, not a group home, and it has staff. Eagle Crest claims it qualifies as a single-family residence under Americans with Disability Act and the Fair Housing Act, and therefore does not need a CUP. That claim is not supported in case law. In Oxford House versus City of Virginia Beach and other federal cases, courts have ruled ADA and FHA do not require residential drug rehabilitation centers to be classified as single-family homes. They also say that they are not exempt from zoning such as the CUP process. Eagle Crest cannot sue for discrimination because a CUP was required. It is required of everyone. Arkansas law prohibits zoning decisions that provide special treatment to one applicant over another. That means the county cannot pass an ordinance tailored to a specific property, especially one that exists from the CUP process required of everyone. Over 2 years ago, this body denied the Eagle Crest Cup. It was sustained by the Circuit Court. Eagle Crest has continued to operate without fixing the issues that led to the denial, and I would believe this constitutes as a reasonable accommodation. They need to provide certification that their septic system is operating properly and adequate for the increased number of occupants. They need to address the concerns of the Arkansas Fire Marshal that told them in 2022 that every structure that was occupied by more than 5 people be sprinklered. And I'd like them to redirect their floodlights away from my property and bedroom windows. This is what the CUP process is for. We're only asking Washington County existing rules be enforced without favoritism. Let Eagle Crest do what every other applicant is required to do. Fix the issues and reapply for a CUP. Now, I also had concerns about the zoning ordinance. Can I come back later for those?
Thank you, sir. Your time's up. Public comments. Thank you.
Hi, my name is Madeline Farquhar, and I'm the lead developer for RES's proposed wind energy project north of Lincoln. RES has operated in the U.S. for over 40 years and developed or built about 10% of the country's wind projects. We're based in Denver, but I'm a proud Arkansan born north of Van Buren and a graduate of the University of Arkansas in soil and water science. I hope to call Washington County home in the future and care deeply about this community. I want to outline 3 key points about the project: our community engagement, our current landowner interest, and our due diligence process. Since last winter, we've sent multiple mailers and hosted 2 public meetings, the most recent at the Cincinnati Fire Station last night. We've spoken with both large and small landowners and began discussions with the County Planning Department and several JPs earlier this year. This project is in the very, very early stages, and while we haven't reached everyone, we're committed to doing so. I just want landowners to know if they're here tonight, if we haven't contacted you, it's not intentional. Your voice absolutely matters. Secondly, I recognize not everyone supports this idea, but we do have a group of over 30 families interested in moving forward. They're working with an independent attorney to review the lease and negotiate terms, and we welcome that. We're not here to rush anyone into a deal. We want partners who are informed and comfortable. And I ask that we respect each landowner's right to make their own decision for their land and for their family's future. The passive income gained from participating in these projects can be life-changing, and the tens of millions of dollars in tax revenue gained by the county as part of these developments will go directly to schools, emergency services, and infrastructure improvements. Additionally, homegrown, in-state energy sources increase our resilience and security. Arkansas's energy demands could triple by 2030 if current development plans are carried out. At the same time, during the same time period, 3,200 megawatts of coal plants are scheduled to retire in the state. Arkansas already imports nearly 50% of its energy needs from out of state, which negatively impacts energy bills. We need every form of energy to remain resilient and secure, and wind energy is currently one of the most affordable. And for those who choose not to participate, the recently passed Arkansas Wind Development Act, Act 945, provides significant protections. This law regulates the wind industry and applies to all Arkansas counties. It requires a high level of community support and establishes triple the industry standard setbacks for turbines from property lines, schools, churches, and more. Finally, as part of our due diligence process, we commission independent third-party studies to determine the effects on the land before a shovel even hits the ground. We're committed to being good stewards of the land, and this process involves extensive and exhaustive review of current conditions, bat and bird habitat studies, aquatic delineation studies, geotechnical studies, and more. Additionally, we have a top-notch engineering team that is standout in the industry for dealing with very complex project design and terrain. Our team truly understands how to design and build these projects using smart, responsible solutions when we encounter issues, and we don't move forward if we find something that's difficult or that's going to cause a fatal flaw in the project. To close, I just want to reiterate.
Thank you, ma'am.
Thank you very much.
Time's expired. Justice Lyons?
I think that's 15 minutes, right?
That is 15 minutes.
So I move that we increase the time by 6 minutes.
3 minutes per individual. I have a motion to extend public comments 3 minutes per person, 6 total by Justice Lyons, second by Justice Rivera Lopez. All those in favor? Aye. Those opposed? Welcome.
My name is Cecily Duncan from Wyman and Durham, a couple different places in the county. I want to echo what JP Massengale stated at the Planning Committee meeting. I'd like to see a coherent land use plan for Washington County. I want to compliment all of you, although I have been critical of you as well. We are facing really challenging circumstances, and that was inherited. None of us created the circumstances we're in. And so we're all in the same boat together. I've really appreciated what JP Lyons has brought to the table in terms of addressing some of the challenges with all the different regulating bodies involved in a lot of different things. One of the things we're challenged by is affordable housing, and Judge Deakins has spoken about deregulation and how cost of building is increased by 30 to 40% just by having to meet regulations. My concern with deregulation is that we live in an economic structure which privatizes the gains and socializes the losses. And so even if those regulations are done away with, is the cost savings going to be passed to those of us who are in a cost of living crisis? And Judge Deakins has also spoken about insanity and doing the same thing over and over again. But our economic model is insane because it is not based on the living world. Everything about the living world is boiled down to an externality. Personal property rights, I'm for that too. But we have to balance that with collective rights as well that impact all of us. I've tried to send the nature-based solutions map to the Planning Committee and to the JPs, but I keep getting send failures, and so it's not going through. But I'd really like for just us to be able to have conversations. There's a lot of good people in the county. We may not agree on everything, but we have a lot of great ideas, and we all want to see the county succeed. And there are a lot of challenges, and the more minds we have together on the issue and the more relationship we can build, the better. And that brings me to the next thing, the communication on the zoning. I wish it was more open and it felt more transparent. But when we've asked for town halls, what we are met with is, well, we don't have the budget to pay the JPs to go to the town halls. But some things are more important than money, and the relationship you hold to the county
Your
is.
time has expired.
Yes,
Appreciate you.
thank you, sir.
Public comments.
Thank you, Judge. Quorum Court, David Baltz, 4459 East Wyman Road. I'd like to first start with thanking you all for the efforts you're doing. Posting videos of these quorum courts online has been very helpful. I will say the last quorum court did start a little bit late. It started at the public comments. I'm not sure why the beginning of the quorum court was missing there. But just wanted to give attention to that so that those of us that might be out of town for business or whatever can still see the full proceedings. I'd like to also bring to attention, thank you to Sam. I brought to attention him after some persistence, the Stewart's Light Show at 4279 Wyman Road. I just want to add this to Eagle Crest, and I'm looking at the audience here because this is everybody that knows. I'm preaching to the choir here, but we're losing our county. We're losing our county to the lack of zoning, and because we're saying we're inept to it, we don't have the funding, we don't have the ability to do that. So what do we need to put in play? I implore this quorum court, where do we need to put in play to get control of our county? The building that's rampant, that's out of control, that you have no control over. Just reaching out. I've been told to go to planning. No, let's go to your deputy sheriff. I talked to a deputy sheriff who was working about planning. Why would I go to a deputy sheriff about planning, Sam? I don't know, but that's where they sent me. Not your fault. I wasn't transferred there or told to go there. I mean, Butch, we had our own discussion. We know where I stand with you, buddy. But I just want to say, and I shouldn't call anybody out in the quorum court, and I apologize about that. But I want to bring a real attention to, we are losing our county to development that is not allowed, that should not be allowed. Call for zoning in our county. We need this clear and concise. Thank you.
Thank you. With that, we're going to move forward. Item number 6 is approval of the minutes. The minutes were delivered with your packets. Do I have a motion to accept the minutes? motion to accept the minutes by Justice Dean, second by Justice Lyons. All those in favor? Those opposed? The minutes have been accepted. Item number 7 is the county judge's report. Once again, I want to thank the staffs and the participants of the Washington County Master Gardeners for bringing us refreshments this evening. The courthouse was closed today for a holiday, but they were still here, and I really, really appreciate that, and appreciate you, ladies and gentlemen, being here too to do the people's business. The disposal report is in your packet. If you have any questions there, please get with me. The number one theme tonight that I want to talk about is the weather. You know, we've all had a very rainy spring, stormy spring, and we are all very aware of that right here. That, of course, impacts county business, and I want to talk about it in some very distinct ways right now. Of course, our roads department. We continue to work very hard and restore our road infrastructure around the county, especially our dirt roads. For those of you who don't know, the men and women of the Washington County Road Department maintain 1,000 road miles, and approximately half of those are dirt roads. So those take a beating anytime we have storms or heavy rains like we did, and so they're still working through those to get roads passable, to get tiles cleared or replaced, and so all that to say, please have patience with our men and women. They're working very hard in the county. If you've reported your issue and you haven't seen the attention there, it's probably because we're triaging that issue and trying to get the most consequential issues addressed first. We will be around to clean up and help. That being said, if you're still experiencing road concerns and you don't believe they've been addressed, the number to the road department is 444-1610, or log on to our website, washingtoncountyar.gov. You'll look at the top of that web page, and there's a button there to submit road concerns, and that gives road leadership and myself date-stamped concerns so that we can begin following up on that. The other thing is the EOC, our Emergency Operations Center on the South Campus, continues to go well. That construction project is ahead of time and under budget, as our building commissioner, Lance Johnson, likes to say. But now it's being even highlighted to us more what a timely decision that was with all the storms that we face in Washington County now, and how that will centralize our response and only help our first responders be better at their jobs that they're already superb at. So really, really excited to see that come online, and probably at a very consequential time as we've seen more weather activity in this area than probably historically known. Rural PSA, our good friends at the Washington County Farm Bureau, I get to hang out with them quite a bit. They asked that we just give a PSA. This time of year, all of our agricultural communities are bringing in their harvests, so please, if you're traveling our county roads, watch out for that equipment and those farmers. Of course, that machinery moves slowly, makes wide turns, and so please just watch out for those, ladies and gentlemen. I think the biggest question now, after the Razorbacks unfortunately lost last night, is when to cut your hay and bring it in. I hear a lot of talk about that, and so look for a lot of farm equipment on the roadways of Washington County over the next couple weeks. You know, we live and do business a lot of times in an urban area around here, but want to also give kudos and hats off to our farming community, our agricultural community here in Washington County, who still leads the state. And so we're still a top agricultural county, and just want to watch out for those, ladies and gentlemen. I had the pleasure to go to a conference last week talking about planning and zoning. And it was very interesting to hear people from around the nation who are addressing many of these same issues. What I will say is, we are a growing area. We know that. We are exploding. When I go to conferences like that, individuals will ask me where I'm from, and I say Northwest Arkansas. You know, sometimes you're talking to individuals from pre-urban areas, and they can quickly dismiss that. But then you tell them that 38 individuals a day move into this region, and everyone's eyes go wide open at that point. So all I can say is my office continues to support your work in this planning mission. Whatever we get done this evening, the only thing I can ask of you is that we urgently move on to the next thing to improve this planning code, or whatever your decisions are, your pleasure. We need to fix this for Washington County. One of the things that I left that conference with is there's many places around the nation that look back with hindsight, 2020, and a lot of regret. And I'm sitting here right now trying to just say we're on the precipice of either making this a great success or really messing it up. I feel like we're at a crossroads right now, and so heavy responsibility lies within your shoulders. Once again, the judge's office and my staff are here to help you any way we can, facilitate this process, and continue to work forward. We must continue this work for the people of Washington County. The final thing is, looking at the calendar, we won't meet again in this official capacity before the 4th of July. And so what I want to say is, what a wonderful nation we live in. We come into this room monthly, and we debate each other, and we have arguments over our future. And what I'd like to stress to everyone is we only have the ability to do that because we are free. And that several leading people 200 and approximately 50 years ago had this bright idea. And think about the people on the earth before then. They had resigned themselves to being subjects of kings and of dictators, but there were some beautiful people that said, we have rights that are self-evident, that are invested in us by God, and that's why we're free. And I'm thankful for that, and I want to wish the whole of Washington County a very successful and celebratory 4th of July. Be safe and have a lot of fun. And with that, let's get into the business of the meeting. First up on the agenda is item 8.1. Counselor, will you read that by title only?
An ordinance creating new planning and zoning law in Washington County and for other matters pertaining thereto.
Justice Ecke?
Thank you, Judge. This ordinance, this discussion has been going on for, my goodness, I don't know how many years. And I'm thankful that we've had these lengthy discussions and given people the opportunity to come voice their opinions. And now is the time for us to pass this ordinance. It, first of all, streamlines and simplifies our planning and building process. Right now, there's so many different variables that make it very difficult for our citizens to navigate through, and this will help streamline that. Secondly, this ordinance is intent is to better protect the rural parts of Washington County, which will allow for actual zoning and rezoning of the property. And we need this structure. Anything needs a good structure and a good foundation. So therefore, I make a motion that we pass ordinance number 8.
This is on its first reading, so
After we read it, I'd like to make a motion to suspend the rules and advance it to the second reading.
I have a motion to suspend the rules and move it to the second reading by Justice Ecke. Do I have a second? Second by Justice Dennis. Justice Coker?
Chair, Judge, I may have missed it because I went to get water, but was there a second to that motion?
To suspend the rules?
No, for what J.P. Ecke motion to pass.
She motioned to suspend the rules and move it to a second reading. Your colleague just to your side there seconded it.
Okay, I was confused then. I thought she had to have a second before she made the next second motion. Thank you.
Okay.
All in favor?
I'm sorry. All right, now we're going to take up, I have a motion to move to suspend the rules and move to the second reading by Justice Ecke, second by Justice Dennis. All those in favor?
Aye.
Those opposed? No. Let's do a show of hands. All those in favor of advancing it to the second reading, please raise your hand. That motion fails. That item will go to a second reading at the next month's meeting.
Thank you, Judge.
Item 9.1. Counselor, will you read that by title only?
An ordinance repealing ordinance 2023-26.
Justice, I'm sorry. Justice Lyons, will you cue your mic? I'll get your question answered.
I want to back up because I had an amendment to that.
Let me get your, I'm sorry. Let me get your, I turned it off again. Please cue your mic. I'm sorry. I'm having technical difficulties here. All right, Justice Lyons.
Before we move on that zoning ordinance, I had an amendment I wanted to move to propose on the zoning ordinance. Are we beyond that?
Counselor can correct me, but once we take the vote on suspending the rules and moving it, once it's read that first time, that ends the debate. We move on to the next item.
Okay. And debate doesn't go to the third reading, so we're gonna go all the way through 3 readings before we come back and amendment and have to go through 3 more readings.
That's correct, sir.
Okay.
No, sir.
So for this one, sorry, the next one.
We're on item number 9. Counselor, will you read that again by title only, just to get us back on track here, sir? This will be item number 9.1.
An ordinance repealing ordinance 2023-26.
Motions or debate on item 9.1? Justice Lyons?
Yeah.
I'll let everybody catch up on the scrolling for a minute. If Justice Lyons, you just continue when you're ready, and maybe that'll give most people time to catch up.
Sorry. It's that zoning ordinance that's in the middle of everything.
Sam, you write War and Peace every time.
Okay, I'm there. So, a couple things on this. Unfortunately, a lot of things that I heard from citizens' comments tonight is somewhat incorrect. First of all, the county doesn't enforce fire code. The fire marshal does, the state fire marshal. We don't have a county fire marshal. The state fire marshal enforces fire code. Secondly, all the septic systems are enforced by the health department. All of our CUPs simply reference state law, state fire marshal, and the health department. So all those things are taken care of by those departments. That's not part of the CUP process, other than we tell them they gotta go to the health department and take care of it, they could go to the fire marshal and take care of it, et cetera. As I understand this, the issue that we have, and the reason the county is being sued for discrimination, is because we do not identify the number of unrelated people that can live in a household in a residential zoning area. So you have 5 college students sitting out here in one household, unrelated, has never been required to go get a cup. Probably has never had a complaint either, and that's kind of how we work. Somebody complains about it, then we look into it, but never required to have a cup. And that's the basis of their suit, as I understand it. And Counselor, you can correct me if I'm wrong, please. Because we require them to have a cup when not requiring others with X number of people or more to get a cup is the basis of their suit. Which is why the zoning ordinance we're going to talk about today has a change to it. It changes to identify the number of people that can live, unrelated, can live in a non-residential household. Had we had that prior to Eagle Crest, and they were over that, then they would have to get a cup, whereas 5 college students wouldn't have to go get a cup. That's the basis I understand it, Counselor. And based on that, I think the discussions, reading through the ADA, all of that information, I believe the county's at risk of losing that suit, and would cost us a lot of money if we lost that suit. Therefore, I make a motion, this is first reading?
That's correct, sir. It's first reading.
So I make a motion, we suspend the rules and move this to a second reading.
I have a motion to suspend the rules and move it to the second reading by Justice Lyons, a second by Justice Dean. Any further discussion?
Only on the motion.
Only on the motion? On the motion to? Okay. Motion by Justice Lyons, second by Justice Dean. All those in favor, say aye. No, sir. I will be very diligent about giving you public comment, Mr. McKinney. You've interrupted this meeting now twice. Please let the board do their business. Okay. All those in favor, say aye. Aye. Those opposed? Show of hands. All those in favor of suspending rules and moving this to the second reading, please raise your hand.
1, 2, 3, 4, 5, 6, 7, 8.
Motion fails. Item 9.1 will move to the second reading at the July meeting. Item number 10. Counselor, will you read this by title only? Takes 10 to suspend the rules and move to the second reading. I did have 8 as a count. Okay.
Item 10 is,
Any help I can get, I'm fine. Justice Coger?
Yes, it would help. Could you repeat what JP Lyons said before his mic was on? He asked a question, and I
Yes.
heard your answer, but I not really hear his question.
To suspend the rules and move it, to suspend the rules for anything, it takes 10 votes of this body, a supermajority. We had a vote count of 8,
Okay.
so that will move to the second reading
I
next
just
month.
wanted to be sure I understood. Thank you.
item 10.
Item 10.1, council, will you please read that by title only?
Item 10 is an ordinance amending ordinance 2025-17.
Justice Bruns?
I'm sorry, I forgot to turn on Michael.
Justice Wilson?
I apologize. I actually had a question, not necessarily on this, but upon a previous item we were.
I think
taking-
we'll wait on that. We've dismissed the gallery this evening, Justice Wilson, if you'd like.
Well, it was kind of related to that, but
Go ahead. I'm not here to preclude you.
Okay,
If
just
you
for-
don't, if you don't think the public,
well, for point of clarification, my guess is a lot of people were here tonight to speak to one or more of these items. I'm not sure everybody in the gallery was clear that they don't get a right to public comments until we are getting ready to take action on that, which would be after the third reading, correct?
I don't disagree.
So.
I think we
but
have confusion up here.
Yeah, and confusion over here sometimes, but of course, a lot of people are gone now, but,
Yeah,
but
okay.
I just thought, to clarify things for anybody who might be watching at home or sitting here in any meeting, you know, we don't take up public comment until we're ready for a vote, which may come after the third reading, but sounds like not everybody here was clear on that tonight.
That is correct. We operate under the Robert's Rules of Order and have done so for.
That's state law.
That's state law. So,
And I
Counselor,
asked
will
just
you?
for the benefit of those who
Yeah.
maybe
Thank
come
you.
here once a year or something.
Yep.
Thank you.
Counselor, will you read item 10.1 by title only again?
10.1 is an ordinance amending ordinance 2025-17.
Without objection, Counselor has a comment to make on this particular item. Would you like to do that now or after debate? Counselor, go ahead.
So I think some emails have been sent, or I think you guys got an email about this as it applies to the handbook. Items 10 and 11 both apply to the county handbook. Item 10 was something that was in place prior to this new county handbook came out. What this body needs to do is deny item 10. Item 10 amends the 2025-17 ordinance. If you pass that, and then you get up and you pass item 11, you're kind of doing away with what you just passed in item 10, right? So what I think our Director Bennett has for you all tonight is item 11 with an amendment in it that includes the amendment that was included in item 10. Does that make sense? Item 10 was a one small paragraph, might have even just been one sentence, amendment to that policy. And so what we did, the most effective and efficient way to do this would be to get rid of, either remove it from the agenda or vote it down, and then take that up on item 11, because as amended, as she'll show you, it has that amended included with it. That makes it cleaner so that we are just adopting a new handbook, but with that language which you have already indicated that you would like to approve.
Any questions there? I have a lot of mics queued, and I'm confused about whether they want to speak to the item or they have a question about that process. So if you have a question about the process, I know Justice Secchi does. Let's start there, and we'll take them up. Justice Secchi?
Thank you. Counselor, you said that we were to deny item number 10. Can item number 10 just be withdrawn by the sponsor, or once it's on here?
No, it's on the agenda, so you would either need to suspend the rules and remove the item from the agenda or vote it down. Either way would work.
Okay.
But that would be the proper procedure.
Just so that way the sponsor would know what proper motion to make rather than there be a conflict. Thank you.
Any other questions about the process? Do we want to, okay, we'll start. Justice Ricker?
I make a motion to suspend the rules and remove item number 10 from the agenda.
I have a motion to suspend the rules and remove item number 10 by Justice Ricker, a second by Justice Rios Stafford. All those in favor? Aye. Those opposed? Item number 10 has been removed from the agenda. Item number 11. Counselor, will you read that by title only?
Item 11 is an ordinance repealing ordinance 2018-50 and approving the Washington County Handbook.
Justice Lemming?
I'd like to see the handbook. Have we got a copy of it? Just, is this what, all, this, what's, that's it? That's just what we're changing in the handbook? This is taking the place of the blue one that we've always had?
That's
Yes, sir.
correct.
Okay, so this in total replaces it. Okay, thank you.
And just to clarify, this is what you've already had come out of County Services Committee, both of these. They were both on there, and I didn't catch that, and that, I'll take that, because we had one that we'd already kind of had in process for a while, and then the new handbook came in, and I didn't think before that meeting that we needed just to amend the overall new handbook, and so that's kind of what we've done tonight. So you'll notice on there, the language that was in ordinance item 10, you can still find in the same location in the overall new handbook. And so this is what you have now is everything incorporated that you discussed and debated back during the County Services Committee meeting.
Justice Lyons?
Okay, I move that we amend the ordinance by adding what's already in the written one on page 11 regarding post-offer and pre-employment testing to show, it reads, which is in here on page 11, all applicants, full-time and part-time positions will be subject to post-offer pre-employment drug screen. This does not apply to temporary, seasonal, or poor workers. The prospective employee will not be employed until the test results are received by the Human Resource Director. The HR Director will then notify the elected official or department head whether the employee is hireable. A prospective employee cannot start work until the post-offer pre-employment test results is received. I'm amending the one that passed the county services, which did not have this in there, to have this in that one, which I believe we have to do by procedure.
So the proper thing to do would be to make a motion to amend
Yep, what I just
to
said.
include what the packet that you have, because it has more than just that amendment. It has a couple of amendments. It has that and the
Okay.
previous amendment. So
So-
you want to move to amend what had passed out of committee and that
What's in here.
to include what the packet that was handed out, include these amendments.
So that's my amendment. So the one term she added here, full-time military service, state, county, takes care of that whole number 10, because there's a whole lot more in there. Okay, thank you. So I moved that we amend to include what's in the copy
Motion.
handed out.
Motion to amend the pre-employment drug screening by Justice Lyons by what's in the packet. I had second by Justice Ecke. Any further discussion on the amendment? Sorry. Justice Lemming?
Brian, can you give me your definition of subjective?
Honestly, I don't have a copy of that in front of me, so I don't know what we're.
11, it's what he's talking about.
Where it says, all applicants will be subjected
Yeah,
to,
yeah, what does that mean?
that means they're
Subjective.
subject to this
Is
test.
it may or may not?
No, it's a shall.
It shall, okay, that's
Shall,
what I wanted
yes.
to know. Thank
Says
you.
all applicants
Shall.
will be, which we could say, it could say shall be subjected, will be is affirmative,
if it-
so that it's not optional.
I mean, because to me, it's subjective. If it's may or may not, that means they could or could not be
Right.
requested. So I think the word shall would be better in there. Thank you. Or making positive, have to.
You could make a motion to change the will to a shall, if you would like.
Mr. Lyons, would you accept that motion?
I don't think I'm.
It's in your amendment. I mean, I could amend it to say shall. I mean, just as long as it,
Well, so based on what we got into before, should we vote on the amendment and then come back and amend it again?
I'd rather do that.
Sure.
Because you can't do friendly amendments.
Yeah, based on,
Well, you can have two amendments. Right now, you have one amendment, and that amendment is to basically substitute this packet for what was passed. Now, you can have a second amendment to another amendment that amends the amendment, But that would be it. You would then have to start getting rid of those before you could go to something. But it's really up to the body on what you want to do. So if you want to vote on,
I just want to put one word in there, whatever it takes.
I'll second Willie's motion.
so I want to make sure I'm going to read this correctly. This is on page 11 under subsection C. It'll say, we're going to amend the first will to a shall. So that'll read, all applicants for full-time and part-time positions shall be subjected to a post-offer pre-employment drug screen.
That sounds good, thank you.
Justice Coger, did you want to discuss the amendment, or you want to make the main motion, or?
No, Judge, I'm just waiting in line for it to speak.
Okay. Not on the amendment, though. Okay. So,
Debate's on the amendment right now.
Are-
Will J.P. Lemming's
are
amendment.
the debate's on the amendment, which includes Justice Lyons' amendment with the inclusion of your
Well, no,
shall.
We'll take up his first. We got to take his up first, sorry.
Okay, never mind. We're going to take yours up first. I mean, I guess my only question about that, and I'm not trying to jump us down, we're amending an amendment that doesn't exist yet.
Well, we're amending the amendment, so if it passes, then the amendment that we're looking at
All right.
will incorporate the new language.
I'm not here to cause trouble. I have a motion to amend by Justice Lemming, second by Justice Pond. All those in favor? Aye. Those opposed? The second amendment passes. Back to the original amendment by Justice Lyons, second by Justice Dean. Any discussion on that? All those in favor of the original, I believe Justice Coger said she's waiting on the main motion still? Okay. All in favor, say aye. Aye. Those opposed? The second amendment has passed, or the first amendment has passed. The amended amendment. You're right. Any further discussion on this item? I would still entertain a motion to include the vacation change. Is it in there?
Yeah.
Oh, we don't need to
Yes,
amend it?
no.
Okay. Justice Coger?
Thank you, Chair. Thank you, Judge. Okay, I too would like to make an amendment, some amendments. I would like to amend what was passed out of committee last time on this ordinance. And I have, starting on page 16, I make a motion to remove the paragraph that says Washington County policy, and it has that asterisk. There's that whole paragraph I would like to take out. That's part of my motion. My second amendment is on page,
Let's take them up once, we'll take them up one at a time.
What was the first one?
it's on page 16. It's a paragraph right before the county reserves the right to alter vacation schedules. That paragraph that starts with Washington County policy and an asterisk.
So your motion is to remove that entire paragraph, correct?
Yes, sir, but that's one, that's part of my,
Okay, well, we need to do each amendment one by one.
oh, okay.
Yep.
Okay. But then I would like to speak to why I'm making the amendment. Okay.
No, let's wait, just
What?
a second.
So I'm sorry, the amendments would remove that whole paragraph?
Washington County policy?
Yes, the amendment is on page 16. The amendment would remove the following. Washington County policy requires all applicable vacation be used prior to authorizing an unpaid leave of absence. In accordance with this directive, vacation will automatically be substituted when there is insufficient balance of a requested leave. In the case of FMLA, sick time will automatically be used first based on the FMLA policy set forth by Washington County.
We have a motion to eliminate that paragraph by Justice Coger. Do we have a second?
Judge, I want to speak to why I'm doing that.
And we will when we have a second. Second. Justice Coger, you want to go into it now?
I do, thank you very much. So it's unfortunate that I went by the page number. The reason I'm making this amendment and the other amendments that I will bring forward is, we all know that vacation time is not just a perk. It's a critical part of maintaining a healthy, productive workforce. Time away from work improves mental health, reduces burnout, strengthens family connections, and helps employees return to their roles refreshed and re-energized. When we talk about supporting our staff, this is one of the simplest, most effective tools that we have. Medical and sick leave, including family leave, are for serious situations, medical emergencies, childbirth, caregiving responsibilities, requiring employees to use their hard-earned vacation days during these often very stressful and emotionally difficult times. Take something valuable that they've earned to support their own well-being. What kind of a message are we sending if we treat vacation time not as something restorative, but as a cushion to be used up before they're allowed to deal with a family crisis or personal health emergency? Our employees in Washington County are our greatest asset. We rely on them every day to serve the public with professionalism, care, and integrity. Allowing them to keep and use their vacation time as intended for rest and restoration is a small but meaningful way to show we value them, not just as workers, but as people. I don't want us to take away anything that supports health, morale, and long-term retention. And from my own personal experience, I worked for 43 years in a law firm, and we never required that anyone use their vacation time for sick leave or family leave. So the other two amendments that I will bring forward deal with that, and that's why I'm bringing them. Thank you.
Director Bennett, do you have any comments on this proposed amendment? You know, I'd also like to take this moment to say, this handbook was worked on for a long time. And I'm going to speak for my staff to say this is a little bit unfair to bring these hugely consequential amendments without ever discussing this with this staff member. Director Bennett?
Thank you. I think if I could just take a moment, whenever JP Koger reached out with some questions, I answered very technically and legalese and cited some statutes and things. And I was thinking about this on the way to work today. There was a theme behind your questions. And I think it was really this lack of trust and transparency that has been somewhat historic from HR to the JPs, from HR to our electeds, from HR to our employees. And I just want you all to know, we have really worked, when I say we've worked on this handbook, I came over in February, as you all know, and we pretty much started right out the gate to start working on this. Your electeds have all reviewed this, weighed in on it, discussed it, spent hours discussing it. We have met with your employees and gotten their feedback, talked to them about the changes. So when we say we've put a lot of effort and work into this, we certainly have. And I echo the importance of people being able to use their sick and vacation time and how important that is, right? And I think maybe just a little bit of context about this paragraph. It's really talking about unpaid leave. So what we're trying to say is, if you're gonna go on an unpaid leave, first of all, most people want to be paid if they're gonna be out, and so they're gonna want to use their sick and vacation before they go on an unpaid leave anyway, right? And so if there is a situation where someone has utilized all their sick and vacation, something has come up, they wanna go on an unpaid leave, they can do that as long as they have used up their sick and unpaid. So I just thought I would clarify that a little bit. And then you mentioned the FMLA part, so I just want to clarify that too. So we, in the past, I think you're probably thinking about maybe the way the handbook was in the past, people, when they were on FMLA, they stopped accruing sick and vacation time. So to your point, they come back from FMLA and they don't have any time where they can actually take off for follow-ups. And that's probably where your heart's at, right? So really, our handbook actually took that language out. So when people are on FMLA, they continue to accrue their sick and vacation. So that's probably something I maybe didn't do a good job of calling out, but I think that kind of solves for what you're looking at. Does that help answer your question?
I didn't have a question. Did I ask a question? I don't remember asking a question.
I'm sorry, your amendment, sorry.
Oh, okay.
Justice Lyons?
Thank you. Yeah, please stay. I don't understand the basis. The basis I heard you talk about didn't match the amendment you want to do. You use the word vacation a lot in reference to FMLA, and it says nothing about using vacation for FMLA unless, Director Bennett, and this is where I want your input, there's a statement here. Vacation will be automatically substituted when there is inefficient balance of a requested leave. I'm not sure what that's referencing or how that applies.
Yes, sir. So let's say someone did not take advantage of our amazing catastrophic leave, which we're really encouraging people to use. Let's say they didn't have that and they didn't have short-term disability. So when you're on FMLA, you have 12 weeks, right? Where your job is protected, but you're not paid during that time. So if you've used up your sick and vacation, or if you've used up your sick time, you use your sick time first and then your vacation.
Okay.
And that way it's trying to keep people whole.
Okay, so that is where the vacation does come in.
Yes, sir.
Because, I mean, when you read this, it's really about using all your sick leave, really it's about using your sick leave before FMLA is what it says, not your
Sick
vacation.
leave, yeah, and then
But
vacation.
again, I understand that if you're trying to take sick leave and you need more, but you're out of sick leave, then you would take, so really, there's, in my mind, it really doesn't apply unless you're out of sick leave. So I honestly don't have any issue with this. I think we're doing the best for our employees. Sick leave is for those things that FMLA is for, that's extended beyond what you might have sick leave for, and it protects your job, right? So
Yes, sir.
I think we're doing the best thing for everybody. To your point, taking out the one where they don't accrue vacation while they're on the FMLA, and they do accrue that now, I mean, just ups that to be better for our staff. So I really don't understand. I will not support taking this paragraph out. And the way I heard it, I don't believe the basis that was identified why this amendment was posed is really a good basis to remove it. Thank you, Judge.
Justice Leming?
Thank you, Judge. I think the county, as many employees that we have to have this kind of language in here. There's a lot of employees that comes to work that saves a lot of vacation and sick leave, and there's some employees that's been here 30 years that don't have a day of either one. So that's called abuse from the employee side of it. Most of the employees that takes advantage of all this takes care of all this, and you don't have this fight. So I think this language needs to be in here. Thank you.
Justice Coger?
Thank you, Judge. My whole point is, I was just trying to give them, I want the employees to have an option. If they want to use that, their vacation time, they should certainly be allowed to do that. But I don't think they should be required to. That's what this amendment and the other two amendments that I have is trying to accomplish. Thank you.
We're ready for the question? Oh, sorry. Justice Ricker?
Just a quick question. If an employee, say, has a baby and they want to take their sick leave, they can take 2 weeks of sick leave that they've got built up and then start FMLA, or does FMLA start from day one?
If you're talking about the person who's had the baby?
Right.
Or, yeah. So
They can burn up their sick leave first and then start their FMLA leave, or does it all start on day one?
it should start on day one.
Okay. Just curious.
Let me address that. FMLA requires an employer to give an employee a certain amount of time off. And so it runs concurrent with any paid time off that you may have. And so let's say that you have a week of sick time and you have a baby under FMLA or have some incident where you're taking FMLA, you'll get your 1 week paid. But FMLA time runs because it says this employee can be gone from the job for this amount of time without you getting rid of them or firing them. You have to protect their employment for this amount of time. And so that's all that. It's a complete separate thing from the time off that someone may have, how much they may get paid. That's what that is. Yeah.
Where I always worked before, we were too small to have FMLA.
Okay. Justice Rivera Lopez?
Thank you, Judge. I just have a question. I believe that I am understanding. I do trust you. I think that you've been marvelous in your role. When it says that the county reserves the right to alter vacation schedules, this is because certain certain balances of either vacation balances or sick leave balances, those would go before you started not getting paid while you were on FMLA, or I'm not understanding then, please help me to understand here.
Great question. That's actually more about giving the electeds or department heads, let's say it's tax season and everybody wants to be out on vacation at the same time. It gives them the flexibility to say, we can have a couple of people out, but we're gonna have also that coverage. So that's what that's actually speaking to. Yeah.
Gotcha.
Are we ready for the question? This will be on the amendment to remove the paragraph from item number 16. Motion by Justice Coger, second by Justice Hires. All those in favor of the amendment, please say aye. All those opposed? No. The amendment is defeated. Back to the original. Justice Coger?
Yes, just for clarification before I get started, both of these amendments concern the same thing, but I still need to make them one at a time. Is that correct?
Absolutely, I think so.
Okay, I want to be sure. So if you will, please go to page 18, the third paragraph down. I'll give everybody time to get there. Okay, everybody there?
Yep.
Okay, in that first sentence, I would like to take out the words "will be charged vacation time" and insert these words after the word "they." May, at their discretion, use their accrued vacation time, period. Oh, page 18.
I have a motion by Justice Coger for page 18. The third paragraph, first sentence, we're striking the words after the comma. We'll leave "they." The words "will be charged vacation time" will be struck and replaced by
May, at their discretion, use their vacation time.
Use their accrued vacation time,
Use their accrued
if that makes a difference.
vacation time.
We have a motion. Do we have a second? That amendment fails for a lack of a second. Ms. Coger, Justice Coger, do you have another amendment?
Yes, I do.
Let's hear it.
This amendment, if you will, please go to page 25. And I did send these amendments out in an email, but it was late today. It was about mid-afternoon. If you will, please look on page 25, the paragraph E, where it says use of sick and vacation time. I would like, in that first sentence, my amendment is to take out the words "will be required to" and have it read, when leave is taken under FMLA, comma, employees may utilize all of their available accrued sick time and vacation time before becoming eligible for unpaid leave, period. That's my amendment. Thank you.
Counselor, can you repeat that amendment to make sure we have it right?
Page 25, section E, the sentence would remove "will be required to" and would insert "when leave is taken under FMLA may." Therefore, that sentence would then be changed to when leave is taken under FMLA, employees, when leave is taken under FMLA, may utilize all of their available accrued sick time and vacation time before becoming eligible for unpaid leave.
That's the amendment. Do we have a second? That amendment dies for a lack of a second. Back to the main motion. I'm not sure we've had one. Justice Lyons?
I move that we suspend the rules and move this to a second reading.
I have a motion to suspend the rules and move this to a second reading by Justice Lyons, second by Justice Dean. All those in favor, say aye. Aye. Those opposed? No. Counselor, will you read this item for the second time?
An ordinance repealing Ordinance 2018-50 and approving the Washington County Handbook.
Justice Lyons?
I move that we suspend the rules and move it to a third and final reading.
I have a motion to suspend the rules and move to a third and final reading by Justice Lyons, second by Justice Dean. All those in favor? Aye. Those opposed? No. Counselor, will you read this for a third and final time?
An ordinance repealing Ordinance 2018-50 and approving the Washington County Handbook.
Justice Lyons?
I move Move we pass.
Move we pass item number 11.1 by
sorry.
Justice Lyons, second by Justice Ecke. I'm gonna let her get in here on this, Janine, okay. Any further discussion? Motion to pass. Any public comments on item number 11.1? Seeing none, Mr. Allen, will you please call a roll?
Justice Coger. No. Justice Dennis. Yes. Justice Hires. Yes. Justice Rio Stafford. Yes. Justice Lemming. Yes. Justice Ricker. Yes. Justice Pond. Yes. Justice Bruns. Yes. Justice Wilson. Yes. Justice Massengill. Yes. Justice Rivera Lopez. Yes. Justice Lyons. Yes. Justice Ecke. Yes. Justice Dean. Yes. Justice Washington. Yes.
That item passes. Item number 12.1, Counselor, will you read that by title only?
This is one of, this is.
That motion failed.
Yes,
It
that's right.
failed.
Anytime one JP objects to a consent agenda item, then it fails. Okay.
Item number 12, will you read that by title only?
An ordinance recognizing and appropriating additional revenue in the amount of $280,626.60 in the Drug Court Grant Fund for 2025.
Motions or discussion on item number 12.1? Justice Ricker?
Make a motion to pass.
I have a motion to pass item number 12.1 by Justice Ricker, a second by Justice Lyons. Any further discussion on item number 12.1? Any public comments on item number 12.1? Seeing none, this is a motion to pass item 12.1 by Justice Ricker, a second by Justice Lyons. Mr. Allen, will you please call the roll?
Justice Coger. Yes. Justice Dennis. Yes. Justice Hires. Yes. Justice Rio Stafford. Yes. Justice Lemming. Yes. Justice Ricker. Yes. Justice Pond. Yes. Justice Bruns. Yes. Justice Wilson. Yes. Justice Massengill. Yes. Justice Rivera Lopez. Yes. Justice Lyons. Yes. Justice Ecke. Yes. Justice Dean. Yes. Justice Washington. Yes.
Item number 12 passes. Item number 13. Counsel, will you read that item by title only?
An ordinance recognizing additional revenue in the amount of $6,134.77 and appropriating said $6,134.77 to various line items and various budgets for 2025.
Motions or discussion on item number 13.1? Justice Ecke?
Thank you, Judge. I'd like to make a motion that we pass item number 13, and this has to do with the JDC and Election Commission renegotiating their contracts.
Second.
I have a motion to pass by Justice Ecke, second by Justice Dean. Any further discussion on this item? Justice Coger?
Judge, I just want to make a point of clarification. The reason I objected to adding to the consent was I didn't have time to find the agenda and know which ones we were at exactly. That's
thank
why
you.
I voted against it.
Appreciate that. Any further discussion on item number 13.1? You know, I'd just like to say this is an example of what our team's doing, our purchasing director and her team getting with these different departments. We love to bring money back to you guys. We hope that the dollar figures are a little bit bigger in the future, but I want to say we have some incredible work currently going on, and I think we're going to be able to bring you more successes like this in terms of the financial state of our county. With that, any public comments on item number 13.1? Seeing none, Mr. Allen, will you please call a roll? This is to pass item number 13.1, motion by Justice Ecke, second by Justice Dean.
Justice Coger. Yes. Justice Dennis. Yes. Justice Hires. Yes. Justice Rio Stafford. Yes. Justice Lemming. Yes. Justice Ricker. Yes. Justice Pond. Yes. Justice Bruns. No. Justice Wilson. Yes. Justice Massengill. Yes. Justice Rivera Lopez. Yes. Justice Lyons. Yes. Justice Ecke. Yes. Justice Dean. Yes. Justice Washington. Yes.
Item number 13.1 passes. Item number 14.1. Council, will you read that by title only?
An ordinance appropriating $800,000 from the unappropriated reserves in the general fund to the EOC Construction Project Fund budget for 2025.
Motions or discussion? Justice Secchi.
Yes, I'd like to make a motion that we pass 14.1, and just for point of clarification, this has to do with our emergency command center, which after these storms that we experienced, those in Town and Springdale experienced power outages, huge oak trees down, and it was categorized as an F1 tornado that passed through there. And we need our own center. We don't need to meet in a parking lot, and that's our command center after a tornado hit. So I move to pass.
I have a motion to pass by Justice Secchi, second by Justice Dean. Further discussion? Any public comments on item 14.1? You turned it off. Just a second.
Hear me?
You're good.
Awesome. We are again allowing $800,000 to go to a EOC that only deals with wind and tornado damage. There's no responsibility for taking care of vapors, and it should be. There is an entity called ATFDR. It's an Agency for Toxic Substances and Disease Registry. They have an emergency line 24 hours a day, an emergency response that you call for issues that you might have. And I feel like the EOC should be in contact with those. The people at ATFDR said they would need to be referred, need to refer a complaint to them before that they could, excuse me, before they could come and help us out. So we have nobody in Washington County that takes care of vapors. Everybody points to ADEQ. ADEQ is not doing anything for the purpose. I'm asking that EOC do that, whether you need to change their initiatives or whatever. But we need help out here, excuse me, in Tawny Town, because people are getting sick. Parkinson's disease comes direct from acrolein. You can point that back at your different things through science. And don't nobody believe nothing till you point at science. So I would like for y'all to consider some responsibility for helping the citizens dealing with this. And of course, excuse me, Mr. John Luther won't talk to me still, and I'm appalled by the actions of county judge toward some people in this horseshoe. I don't understand. If you can't control your attitude, you need to ask somebody else to lead the committee. Thank you.
Thank you. Will you say your name and your address for the record?
Yes, sir. Kenneth Lovett,
Thank you.
18702 Clearwater Road. I'm sure you know that
Great.
already.
Mr. Allen, will you please call the roll? This is to pass item number 14.1.
Justice Coger? Yes. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean? Yes. Justice Washington? Yes.
Item number 14.1 passes. Item number 15.1. Council, will you read that by title only?
An ordinance ratifying a conditional use permit recommended for approval by the Planning Board for the Social Sauna Pop-Up Project.
This item's on first reading. Any other discussion or comments? Justice Lemming?
I'm sure Sam's getting up here to tell us about it. That's what I really needed to know. Thank you, Judge.
I'm here for the looks. Good
Dr.
evening,
Addo, would
everyone.
you like to give a summary of this?
Absolutely. So this project was approved by the 6 member available, present at the June 5th meeting. 1 member left before making a vote on it. So the area is about 4 acres. The applicant is using only 0.78 of acres of them. So just to clarify, there is lots of stuff happening on the property. She has dog kennels, and she has a house that she uses for Airbnb, but this is not part of the CUP. The CUP only for a sauna use that she is going to be using with fences. And we listened to the neighbors, and we took all their comments, and we used them as approval conditions, all of them in the back. So the other thing, the fire department is across the street, and we already contacted the fire department during the process of the technical review, and he responded there is no issue. The only comment he said, if there is anything going to be built, it needs to be built from the factory. So there is no MacGyvering or nothing handmade. So, and I guess that's what the applicant is doing. She is purchasing a unit that comes standard from UL approved, comes from I guess Wisconsin, was it? Minnesota, so something, yeah, close. So it's something north, and that's what they use. So it's not something she's going to build or something is going to be done locally. It's a company that specializes in these things, and that's why the fire department has no issue with it. The other thing, as I said, there is a lot of restrictions on it when it comes to morality, safety, fire hazards, septic. So we talked to the health department also during many times, and we received another email from them yesterday. So we discussed back and forth. The septic is useful for up to 20 people. So, and she is not going to be having more than that. The only thing that she changed and she requested from the planning board is to change the hours from 4 to 9 to 3 to 9, and they approved it because she's going to have a maximum of 3 sessions, 2 hours or 3 hours each. And she's not going to have more than one session, or that session is going to be only 1 day a week. So it's not a continuous thing. It's not going to be every day. It's not going to be forever. And if you have any other questions, I'm happy to answer.
Questions for staff? Will you please cue your mic, Justice Pond?
And for the sake of further discussion, and we have people here for public comment, I'll move to suspend the rules and have this come to the second reading.
I have a motion to suspend the rules and move it to a second reading by Justice Pond. I heard second by Justice Dean. All those in favor? This is to suspend the rules and move it to a second reading. All those in favor, aye? Aye. Those opposed? No. Ayes have it. Counsel, will you read this for a second time?
An ordinance ratifying a conditional use. An ordinance ratifying a conditional use permit recommended for approval by the planning board for the social sauna pop-up project.
Justice Pond.
Move to suspend the rules and do the third reading.
I have a motion to suspend the rules and move it to a third and final reading by Justice Pond, second by Justice Dean. All those in favor? Aye. Those opposed? No. Counsel, will you read this for a third and final time?
An ordinance ratifying a conditional use permit recommended for approval by the planning board for the social sauna pop-up project.
Now, back to further discussion.
Now I have some questions for Mr. Sam.
Yes, sir.
Just to be clear, I think I've heard all this. If this is approved, that would still be upon approval from the health department. Is that correct?
It's already, the applicant already did the DR, the designated representative came and gave an inspection, and the health department already approved and the septic, and we have that documentation, and it's being posted in the staff report. So we have all the documentation and the inspection. But if you want this to be inspected again, I mean, we can always request this. We we can always request this to be done again. It's not a big deal.
It's already, so you have documentation
Yep.
where they have approved?
Yes, and one of the only restriction that the health department mentioned, they are not supposed to be using soap, so they are not good, like the customer is not using soap, so they're not lathering to create like a gray water. They're only going to be splashing themselves because like once you leave the sauna, it's too hot, and that will like be okay with the health department and the septic system itself, because it's not designed like for the existing septic, like it's not designed like for like soap.
For the sake of the information to the public, what activity is this? What is a pop-up sauna?
The applicant is here. She can
Alright.
explain more. I mean, I have everything here, but like she
Yeah,
is
I
more
will-
passionate about this
alright.
project than me.
I'd appreciate that. Thank you, Sam.
Hi there, I'm Ali Maracek. This is my proposal. So sauna is a wellness practice. It has a lot of health benefits like stress reduction and, it affects in a positive way almost every body system, just really bringing resilience to your life, helps you manage stressful situations. And so it's been around for a long time. Traditionally, it's from Finland. It's a Nordic practice, and it is cold contrast. So you spend time in the hot sauna, which is a dry sauna. It's not a bathhouse. It's where you pour the water over the rocks and it creates steam. And then traditionally in Finland, they would jump in a lake, but I don't have one of those. So there is the cold shower. There's no hot water to it. There's no soap in the area, and it's basically just to relieve the kind of hot feeling and bring that cardiovascular benefit. It's great for the heart and your other organs. And then you can rest, drink water, and then go back into the sauna. Usually people will cycle through that 2 or 3 times during a session, and it's just really relaxing. It's a kind of like a yoga practice. These would be like you would show up like yoga. Like you book a session and you go, so it's more meditative, relaxing. There is a social aspect in that you come with your friends. There's no cell phones, no alcohol. You're just coming to hang out with your friends, maybe meet some new people while you're there, since up to 10 people could join a session. So it's really just to build connection. I feel like we're so disconnected these days and distracted with our cell phones and other vices, and it's a nice place to just be in nature. It's why I picked that property. I just love the natural setting, and we don't get a lot of opportunities to be in nature, and this is a nice way to do that.
Thank you. And it's written in the conditions that there will be a dress code.
Yes, yes.
And you have privacy fence,
Mhm.
is that correct?
Yes, when they book a session, they will sign a waiver for code of conduct, dress code, just kind of general behavior and expectations in the area. And
Do we get the no amplified music?
right, I put in my application that there might be some relaxing music during business hours, but it won't be amplified.
In the no alcoholic beverages, and I don't mean to sound like I just disapprove of drinking altogether, but in this rural setting, and the county judge already brought up earlier this evening, there is, in these rural roads, there is a lot of slow-moving traffic on these. And so it's a nice thing that we don't have people that have been partaking alcoholic beverages and then
right.
get onto a road where there might be farm equipment moving or and that sort of thing. And I do appreciate that.
Yeah, and that kind of changes the experience too. Then it creates more of like a party environment, which is I'm not going for. And also, it's not safe to drink in the sauna, so there'll be definitely like signage and.
Okay, and so a sauna it's like a hot room.
Yeah, it's a hot room. Yep.
co-
People wear a bathing
basically
suit
what
or
it
gym
is.
clothes. Mhm.
It might be warm enough in there that you might not want any kind of metal objects hanging around your neck or anything.
Right,
You might get burnt.
yeah, right, yeah.
That's about all I got.
Okay, thank you.
Thank you. There may be other questions.
We do need a motion. We don't have a
Move
motion
to
right now.
pass.
Move to pass. Motion to pass by Justice Pond, second by Justice Lyons. Any further discussion, Justice Rios Stafford?
Thank you, Judge. We had heard at the beginning of this meeting during public comments, and I didn't really totally understand all of it, the context, about the driveway distance. Could you address that, or what that concern is?
Okay.
Or how that's being addressed?
So, during the technical reviews, we always do this. One of the few things we do, we have the, in our like ordinances, like we have the, a table that like everyone uses, which is like derived from the Handbook, which is like the state and the federal like regulations for like driveway and speedways. So we will have like side visibility when you're like leaving right and side visibility when you're leaving left, based on the entrance size and based on the distance and based on the speed on that road. So that's been already like verified, and the engineers, our engineers, like the contract engineers, like did not notice any problem with it. Not saying that nobody is like, let's assume everyone's like doing the speed limit. Nobody's doing the speed limit. I know there is always danger, but like it's always like a good practice for the drivers themselves to be like responsible when they leave. But if the question, did they meet the requirements for like the side distance? Yes, they did.
Okay.
Yep.
That was-
Otherwise, it would have been like requested that like you expand or like change like your entrance and or make another like exit entryway for that property.
Thank you. That was my
Absolutely.
question.
Any further discussion or questions? Justice Lemming?
I just want to make a statement. Thank you, Judge. We was talking about alcohol there. Every CUP, everything we talk about has always got alcohol involved. The University of Arkansas, we have, how many people come to a football game? There's hundreds of thousands of people down there, and how many of them's tailgating? How many of that you think they're drinking water, soda pop? But they're always talking about alcohol. Alcohol's a problem. Alcohol's been a problem forever, and there's laws already against it. So I think that needs to be took out of all of our CUP process. If we're gonna do that, let's tell the University of Arkansas they're gonna have to do it. I mean, goodness gracious. Thank you.
Further discussion? Thank you. Thank you, ma'am. Public comments on item number 15. Are there any additional public comments?
I'm not sure anybody even heard what I said last time. I was talking too fast. I couldn't even understand myself. So if you have any questions of what I said, just go ahead, because I don't even know what I said. But to sum it up, I'm not going to read everything I had, but I'm not here to argue compatibility anymore. Obviously, that's a moot point, but I'm here for you to all look into this septic matter with eyes wide open and prove to yourselves that this is a very old septic system if it's up to the task of all, and I mean all, of what Ally intends to do. It was a one-bedroom house, and I realized that you did a perk test, and it was like, okay, you can have 3 bedrooms. But that's not the point. That's not going to happen. It's not going to be a 3-bedroom family home. This is a commercial property. So now how many people are going to be there in the bed and breakfast, both houses, and in the sauna? And they will shower off. She's got that in her proposal. Shower in the bed and breakfasts afterwards. Our property butts up. We have an old creek back there that backs up every time it rains. That's where her leach system is at. That's what we're concerned about. Go ahead and vote.
Thank you. Public comments?
All right. You're lucky you get the redacted version this time. My name's still Michael Kemper. I still live at 14307 Jasper Lacey Road. And I would like to thank the planning board and this quorum court for all the work you're doing in trying to work towards preserving and protecting the quality of life in rural Washington County. It's certainly appreciated. Now, we've lived out there for 14 years now, and on Jasper Lacey Road. And when I come up to the intersection of Lake Sequoia Drive, that's a nice wide open area. You can see well both directions, and I could not tell you how many times I've looked both ways twice, pull out on the road and just get going, and all of a sudden there's a truck or a car right on my tail. It just scares the bejeebers out of me. But anyway, that's with good visibility. Now, I don't know who checked, I couldn't understand that, who checked it, but I promise you, if you sit there in your car or truck, as I did at the end of the driveway, you look left or right, at best, it's 100 feet, if that you can clearly see. Secondly, the fire pits in that she wants to put in there, for me, that's a major red flag, especially during those long dry spells that we can have. And having spent the majority of my life in leadership positions in the BSA and making fires, in my opinion, those fire pits are a forest fire waiting to happen. And yes, Round Mountain Fire Department is there right across the road, but it is an unmanned station. Now, speaking as a former volunteer firefighter at that station, I can tell you that the response time and responder numbers to call outs is completely dependent on what you might be doing at the time that call goes out. If you're out there helping a heifer have her first calf, you're not going to leave and go respond to a grass fire or a forest fire. If you're out there in the middle of your hay field, that's not going to happen either, or there will be a sufficient delay. Now, over the past few weeks, we have spoken with all of our members, community members that were on that map for notify the neighbor take. And we've spoken to some that are not on that map. Not one single neighbor in the entire community said that they would vote yes on this project. Now, ladies and gentlemen, the serenity of our residential rural property, it's more than just enjoyable.
Thank you, sir.
Okay.
Appreciate your comments. We're going to take up the question.
We have an opportunity to make right.
We have a motion to pass by Justice Pond, a second by Justice Lyons. Mr. Allen, will you please call the roll?
Justice Koger? Yes. Justice Dennis? No. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? No. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes. Justice Ecke? Yes. Justice Dean?
Yes, sir.
Yes. Justice Washington? No.
Item number 15.1 passes. Item number 16, Council, will you read that by title only?
A resolution to recognize the Arkansas 250 Commission as it begins its work to celebrate Arkansas's rich history from the signing of the Declaration of Independence on July 4th, 1776 through July 4th, 2026.
Justice Dean?
Thank you, Judge. This is first reading, correct?
The only
resolution, so it
Yeah.
only needs to be read once. Just the
okay.
motion to pass.
I'd like to go ahead and make a motion to pass this.
I have a motion to pass by Justice Dean and a second by Justice Lyons. Any discussion on this item? Justice Rios Stafford?
Happy birthday, Arkansas.
Any public comments on item number 16.1? Seeing none, Mr. Allen, will you please call a roll? This is a motion to pass item number 16.1 by Justice Dean, a second by Justice Lyons.
Justice Koger? Yes. Justice Dennis? Yes. Justice Hires? Yes. Justice Rios Stafford? Yes. Justice Lemming? Yes. Justice Ricker? Yes. Justice Pond? Yes. Justice Bruns? Yes. Justice Wilson? Yes. Justice Massengill? Yes. Justice Rivera Lopez? Yes. Justice Lyons? Yes. Justice Ecke?
Justice Ecke.
Yes. Justice Dean?
Yes, sir.
Yes. Justice Washington? Yes.
Item number 16 passes unanimously, and I think that's a great note to say the committee reports are in your packet. Everybody have a wonderful 4th of July and celebrate this wonderful nation. We're adjourned.